Hey guys, hello everybody. I got my Facebook. I got my YouTube. I got my IG, YouTube, and Twitter. Hey everybody, how you guys doing? I am here just to give you guys an update of what happened today on the YFN Lucci. Oh Lord, YSL. I don't know what's wrong with me, y'all. I'm delirious right now. I got YFN in the brain. I don't know why. Um, okay, guys, I wanted to do a recap of what happened today at court. And it was kind of crazy, right? It was like so much heated emotion that was going on. I know Dr. TTH, you wanted to come on and say some stuff today. I know you was holding your tongue. So I'm gonna have a session afterwards to give you guys a chance to come up and talk. IG, if you want to come over to YouTube and get on the live, you can do that. But anyway, I want to start off to saying that this morning, court was supposed to start at 10 o'clock, really 9:30-ish, 10 o'clock. When we arrived there this morning, we were told that media couldn't come in, right? And that's why, if you guys notice, you did not get any streaming in the beginning. And the reason why you didn't get any streaming, because the sheriff department did not allow us in. So we sat in the room waiting and trying to figure out why we were not in the room, in the courtroom. So we had a chance to go and ask, and we're just told we can't get in. We can't come in. Then finally, when one of the attorneys was leaving, and we told them that we're not able to get in, she was like, "Why not?" I was like, "I don't know." And I said, "Well, are you leaving for the day?" She says, "Yeah, I'm leaving." And so she says, "Well, I'll text them and find out why you guys are not in," because she want to be able to see too, because she was leaving and she knows we usually stream the actual proceeding. So about, I say, 30 minutes later, we were allowed to get inside the courtroom after she texted, I think, one of the attorneys. And I think the judge didn't even know that they were not allowing us to get in. So the judge was like, "There's nothing wrong." He didn't understand why they had us out. And the rule is, anytime there is some sort of proceeding, the news is supposed to be in there, especially if you have a Rule 22. So we got in. And when we got in, they were still doing a motion in regards to Mr. Kendrick, and his attorney was up there, and they had already argued it by the time we got in. We stayed in there for about 10 minutes, and then we went to lunch, right? So he came back. When he came back, he made his ruling in favor of the evidence was not being able to bring in. So that was a win for them. Yay for Yak Gotti. Now, but during the whole process, they were going back and forth, back and forth, back and forth. In fact, I am going to play a video of them, the back and forth between the attorneys, and then the bailiff had to come in and step in to try to, cease the fire. It was kind of crazy. Hold on a second. Let me see if I can get it up here. Let me see if I can get it up. I got it on my phone. Somebody clicked it. Let me see if I can go into my IG and pull it up from somebody. Instagram. And so you guys can see. I know if you guys got a chance to see my live streaming, you guys was able to see it, but I wanted to show you guys. Hold on a second. There we go. One of my peeps have it out. Hold on a second. They showed it on their channel. Hold on a second, trying to pull it up. They do a lot of work a day in the daytime, I see. Hold on a second, trying to pull it up. I was trying to pull it up. Maybe I can do it from, because if I go play it in my background, maybe I can pull it up from my live earlier. Hold on. Because then you'll be able to see it. Infamous Sylvia. All right, guys, I'm gonna go. Come on over to come on over to YouTube. Okay, guys, come to YouTube. Okay, hold on. Just okay. Here we go. All right, here we go. We're gonna play it for you guys. Let's see.
In such, I have considered as well and will be admitted for purposes of the motion to suppress Jackson Dental hearing. Mr. Kendrick's video statements. In particular, the court has viewed a portion of those particular statements relative to the periods of time at 2:16 p.m. continuing for approximately 3 minutes or thereabouts. Also from 2:56 p.m. continuing to about 2 or 3 minutes. And the court specifically has heard in the first video at 2:16 or thereabouts, near the end of that colloquy with the detectives, I need to talk to my lawyer. I don't want to talk no more.
You heard him say that, right?
At the
Mr. Kendrick says he needs to talk to his lawyer. He does not want to talk no more. So at this point, the detective or whoever it is that's supposed to be doing the interrogation has to stop by law because you have the right to remain silent.
second video, starts at 2:56 p.m., goes for about 2 to 3 minutes or thereabouts, and stops at 2:58 and 53 seconds.
Your Honor, may I address the court?
No, I want to make my ruling. Okay?
Uh-oh.
I haven't presented any evidence.
I can take this on argument, and that's what I'm going to do. I'm going to, in terms of the what's been admitted for the court's consideration, that particular portion of the video is what I need to focus on. What I need to focus on is whether or not Mr. Kendrick was in custody, whether or not Miranda was appropriate at that point in time, and whether or not he invoked his right to counsel.
And whether he reinitiated it.
Yes.
You have the officer to talk about that.
I don't need that at this point in time. I really don't. I'm of the opinion. I also had a chance to take a look at Mr. Uhelski sent me as well, and I'm sure the other counsel got a copy of the United States versus Kendrick, both the district court order, which was a hearing in front of Judge Alan Baberman, the United States magistrate, and then Judge Mark Cohen, United States District Court judge. And then the appellate opinion was an opinion based on sentencing. Mr. Kendrick appealed the severity of his sentence. So I'm taking a look at the appellate order, at the trial court order from Judge Cohen, adopting Judge Baberman's findings.
Right.
And I make it very, of page During the course of page two, during the course of over 2 hours of the initial interview, defendant did not ask to speak to an attorney. At some point during the interview, Detective Joe Galpin, who was investigating a separate homicide incident, entered the room. Defendant then indicated he wanted to talk with his attorney, and questioning stopped. So Judge Baberman, I can't tell whether or not he took into account what I heard on the video, which was, I need to talk to my lawyer. I don't want to talk no more. That is equivocal to this court, me, Judge Glanville, that he invoked his or withdrew his consent at that point in time and did not wish to speak to law enforcement officers anymore. I understand the state's argument about parsing it out, asking for clarification, but I think that once he's, the appellate, case law that I've looked at, in Paldo and others, he has invoked his right at that point in time, and it's this court's opinion that anything thereafter would be inadmissible.
Your Honor, the court also found that he reinitiated, and that was what.
But that's their issue. That's not my issue.
Your Honor, I'm not.
Okay, and to your point earlier, Judge Cohen and Judge Baberman, I can't tell whether or not they listened to what I heard, but you're only as good as the information that you're given.
Right.
So it doesn't say on this particular order that that's what they relied upon. It just says he wished to talk, some point in time, he wanted to speak to his attorney. Now, I'm of the opinion, this court's of the opinion that questioning needs to stop. He's unequivocally revoked. And you can't pick and choose at this point in time whether or not it's to this particular crime or any other assertion. So that's why I'm going to suppress it.
And Your Honor, Your Honor, with respect to the statements that were made after that time, we do have, as I stated, Investigator Thorpe to tell the court on the record, present under oath, that it was not Detective Thorpe, it was the defendant that reinitiated the conversation with Detective Thorpe. Our representations to the court are not evidence, and since the state has the burden of proof.
Okay, but I've seen the video at this point in time.
Video does not encompass when the defendant actually reinitiated contact.
But the problem is, he invokes, and then we don't know what goes on in the 45 minutes, but we come back afterwards, and at that point in time, you don't get to eat your cake, have your cake and eat it too. It's once he invokes, that's it. It's over.
Your Honor,
they should not be bringing him back at that point in time and asking, well, let me just clarify a little bit about whether or not these statements were made to these set of detectives or to Galpin.
It wasn't there in the room that I'm talking about, Your Honor. I'm talking about in the first, the defendant asked for a smoke. So they took him out for a smoke. When they took him out for a smoke, the defendant reinitiated the conversation as they went outside. That is what they found in the district court, but the court doesn't owe that deference. That is why we have, as the burden of proof, holding the burden of proof, that is the reason we have Detective Thorpe here to testify.
I don't need his, I'll consider it, but it's this court's opinion that once he invokes, you don't get another bite at the apple by taking him outside, softening him up, giving him a cigarette, some bonbons or whatever, and then letting him go ahead and then say, oh, well, let me just clarify with you a little bit. That's not how this scenario worked. I think that you all are just annoyed more so that your detective did something that he probably regrets now, and that you all probably would not have told him to do. Don't interrupt this particular investigation or this particular hearing, because what you did is you just now created a wrinkle that now I got to deal with, or whether or not the defendant has invoked his right to counsel. He has.
And Your Honor, I'm not annoyed, Your Honor. I just have, with the burden of proof, we have a person who can speak to the issue rather than having us, sort of speculate as to what happened, because it's not, as the court at this time has indicated that it sees, which is that we softened him up with things.
That's my ruling. And prepare an order suitable on my directives.
Yes, Your Honor. Thank you.
Your Honor, we have not presented any evidence regarding what happened in the Sally Port. Would the court permit the state to present evidence of what happened when they went upon the defendant's request to get a cigarette?
Ms. Love, I'm of the opinion, it's not going to change my mind at this point in time, in terms of, because he's invoked Anything after that would be improper. It really would be, because I mean, it'd be one thing if he said, well, maybe should I get a lawyer? Maybe should I do whatever this, or, kind of kind of make vacillate. But he's pretty significant in the sense of, I need to talk to my lawyer. I don't want to talk to no one.
And Your Honor, our case law shows that even when that happens, when the defendant reinitiates the conversation and communication, that the court has found that those statements made after the defendant reinitiates conversation, as unequivocal as his initial assertion was, when the defendant reinitiates the conversation, the statements that he makes are not to be suppressed. And in this case, the defendant reinitiated the conversation, not the officers. And Your Honor, we've provided to the court, and we have proof. We have actual testimony, given that we do have the burden of proof. Your Honor, Munn versus the state, 313, Georgia 716, says that the court must consider the totality of the circumstances and determine the admissibility of the evidence of the statement under the preponderance of the evidence standard. And Your Honor, given the fact that we have a witness here to testify, the court doesn't have to take my word for it or Mr. Weinstein's word for it. We have the person who was there. The court gets to gauge Detective Thorpe's credibility, and the court then has substantive information and evidence upon which to base a ruling under the actual totality of the circumstances. Right now, we have a clip. When I asked Mr. Weinstein to play for the court the portion to which he objected, that wasn't the state conceding that we weren't going to put up evidence, Your Honor. I was trying for the sake of brevity to have him point out the part that he objected to, but then that left us without the ability to present anything. And we weren't stopping there. We were just showing to the court where he was arguing, the points that he made to us that he wanted to contest. So we would like to present actual evidence to show under a totality of the circumstances.
I got the evidence. It's been admitted. The two videotapes are sufficient for the court's analysis at this point in time. Sir,
yeah.
That's your ruling. Thank you. I have nothing to add, Your Honor.
Right.
And Your Honor, what happened with the Sally Port, the conversation being reinitiated by the defendant, that actually happened, and we have the proof here to show it to the court.
Well, based upon what you've argued so far, in this particular circumstance, this court's of the opinion that it's like this. Once you initiate your right, or you revoke your right to be examined and have counsel, and to have counsel present at that point in time, the courts are very, let's just say, cautious about reinitiation at that point in time. And you all presented to me what was the salient point of this particular issue is. So if I believe at this point in time that he's invoked unequivocally his right to counsel at this point in time, the questioning is supposed to stop. You're not supposed to go out and get cigarettes and do everything else. It's supposed to stop. I mean, that's this court's opinion. And that's my ruling.
And Your Honor, the thing is that, Your Honor, we did not.
You're arguing with me now, Ms. Love. So can we stop at this point in time?
Your Honor.
If you have other evidence independent of this, I'll consider it at the appropriate time.
And we do, and that is what I was asking. So if the court will permit me to actually introduce the evidence that we have, as the court in State versus Paldo 309, Georgia 130, where it says a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning until the suspect reinitiates the conversation. And in that, they are citing Dozier versus the State 306, Georgia at 35. Your Honor, Edwards versus Arizona. And Your Honor, this is a 2020 Georgia Supreme Court case where it specifically says that a suspect who asks for a lawyer at any time during a custodial interrogation may not be subjected to further questioning, as the court has said, by law enforcement until an attorney has been made available, or until the suspect reinitiates the conversation. They
Your
hold those
Honor,
two
at
things.
some
Your
point,
Honor,
Your
I'm sorry,
Honor,
I'm talking,
Your
and
Honor,
I
at
don't know
some
why I am
point,
being interrupted. I will
rulings
not
need
stop.
to be
Your
final.
Honor. I was speaking.
Ms. Love,
I'm sorry, I was
both
speaking.
y'all keep talking at the same time.
I know, I was
Honor, the
speaking, and
state
I
can talk
expect
for
to be
years.
allowed to speak when I'm speaking.
Hey, both of you all need to just take it down a notch.
And so, Your Honor, if I may finish, because I was the one speaking before Mr. Weinstein
But
interrupted.
you continually engage in this pattern of behavior, Ms. Love. You don't want to accept my ruling.
Your Honor,
And I know you're being an advocate, but at some point, stop. Just stop. I made my ruling. Good, bad, or indifferent to you. You're gonna win some, you're gonna lose some.
I do accept that
Okay,
fact.
no,
but
you
Judge, we
don't.
have
No,
not-
you don't.
Your Honor, we have just not been able to present the evidence. that
No,
the-
you don't.
that the
I
state
get it.
has to
I get it. And if you have an independent basis to introduce statements that may not, or that may be not subject to the fruit of the poisonous tree, or any other thing, or any other issue related to evidence that may have flown out of this particular interview, then I'll hear it at that point in time.
When the court says independent basis, does the court mean outside of that video? Because we do have that.
Yeah, if it's not tied to the statement, of course you can introduce it.
Yeah.
I mean, as long as you have some independent basis, right? If you didn't get it from his particular statement.
But Your Honor, that's the point, that we have the witness here, that we brought the witness here, and had him cancel medical appointments to testify to the court about. We brought the witness here.
I
so
made
we
a
could-
ruling. That has nothing to do with it. That's a red herring and you know it.
No, Your Honor, I was saying that we were ready to present evidence, and the court is not allowing us to present the evidence. That's all that I'm saying. We have the burden of proof, and we haven't even been able to present the evidence that we have. We only, for the sake of ease, allowed the court to introduce the statements that the defendant made as states 1 and 2 to help Mr. Weinstein play the portion that he wanted to talk about. We didn't even get a chance to play or to have the evidence that the state has ready for presentation to the court to be presented. We should be entitled to present the evidence so that the court actually has the circumstances and does not have speculation or conjecture as to what happened when the Georgia Supreme Court has clearly said, just as clearly as an attorney being present is required before you consider the statement once he's invoked, the court has as clearly said, if he reinitiates, then that statement can be considered. It does not use them like maybe. It says, if this or that, then the statement can be considered, unless it should be suppressed for another reason. And that case, Paldo, is as recent as 4 years ago. And I'm not just doing this for the sake of engaging in a pattern of behavior, Your Honor. I am standing here emphatically asking that the court allow the state to present its evidence so that the court can make a ruling based on the evidence and not on the assertion by one party or the other as to what should or could be done. We have evidence that I believe that the state is entitled to present and the court is entitled to hear in the form of testimony. And I understand that Mr. Weinstein wants us to hurry it along and not hear Detective Thorpe because that might be an adverse position or evidence to his client's position. But we are simply asking that the court allow us the opportunity to present the evidence and to not hold it against the state that I am asking this, that the court allow us to present evidence that this statement was made voluntarily and that the fact that he ceased it but then reinitiated it is something that the court should consider. And Your Honor, I don't like drawing the court's ire. It's, quite disturbing, but I cannot in good faith not present evidence when we have a whole burden of proof to show the court that it was made freely and voluntarily. And when the evidence that we have is sitting right outside the courtroom. And the court's whole purpose for having these hearings is to determine the truth and to decide what is fair. And without hearing from Detective Thorpe, I don't know how the court can discern what the truth of the matter is, hearing only a portion of a recording and not hearing from the people who were actually standing there talking to and listening to the defendant. Unless without hearing Detective Thorpe, the court is making a credibility judgment before even hearing what he has to say.
May I please speak? Please, may I please speak?
Okay.
And Your Honor,
Yeah.
I was asking that the court,
Are you finished, madam?
I was not, Your Honor. I was
Your
really not.
Honor, she is.
Hold up. You got 30 more seconds. Wrap it up.
And Your Honor, I'd ask again the court for the opportunities for the state to be able to present evidence so that the state can meet its burden and not have the court make any kind of ruling based on really partial pieces when the court does not have a totality of the circumstances as a part of the record for the court to consider. So I would ask the court in earnest to allow us to at least present the testimony of Detective Thorpe, if not today. I don't mind doing it. I said in my email to the court and to counsel that we can do this closer in time because he does have or did have that appointment closer in time to when this matter will be right. But Your Honor, I ask that I implore the court to allow us to actually present the evidence that we have to present. I appreciate Your Honor giving me the moment to speak. Thank you.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop so that
Hold on,
opposing
y'all.
counsel can speak.
Hold on.
Your
He said the state can talk the ears off a donkey. Oh my goodness. And you know, donkeys have a long ears, y'all. Long ears. Oh my goodness. Ears off a poor donkey. Lord, I'm gonna do that one more time. Hold on. Sorry.
I was asking that the court.
Are you finished, madam?
I was not, Your Honor. I was
Your
really
Honor,
not.
she is.
Hold up. You got 30 more seconds. Wrap it up.
And Your Honor, I'd ask again the court for the opportunities for the state to be able to present evidence so that the state can meet its burden and not have the court make any kind of ruling based on really partial pieces when the court does not have a totality of the circumstances as a part of the record for the court to consider. So I would ask the court in earnest to allow us to at least present the testimony of Detective Thorpe, if not today. I don't mind doing it. I said in my email to the court and to counsel that we can do this closer in time because he does have or did have that appointment closer in time to when this matter will be right. But Your Honor, I implore the court to allow us to actually present the evidence that we have to present. I appreciate Your Honor giving me the moment to speak. Thank you.
Your Honor, I apologize for interrupting the state earlier, but the state can talk the ears off a donkey. This continued filibustering has got to stop so that opposing counsel can speak. Your rulings at some point have got to be final, Your Honor. Whether you hear from Detective Thorpe or not is irrelevant. He requested his lawyer. He invoked his right to not speak anymore. And I don't care what schmoozing Detective Thorpe did out at the Sally Port, taking my client off camera. I don't know what went on down there. I don't know what self-serving, well, I have some idea. I don't know what self-serving statement Detective Thorpe could possibly give to this court that would cause the court to change their order. This continued going back whenever the state loses in this case has got to stop at some point, Your Honor. Thank you.
And we're gonna go to lunch after this. Look at Jeffrey smiling. And at this time, he's still, trying to review it, but he's gonna give it to Weinstein. Shout out to Attorney Weinstein. He held his gun. Now, before all of this, before the cameras went on, we don't know what was said in there. We don't know what was going on. All we know is that we were not allowed. But then later on, we found out that the judge did not make that determination of us not being there. It was the sheriff department that had us not entering into the courtroom. Lady Coltrane says she's gonna have to use that one talk the ears off of a donkey. Right country, I love it. She said any statement obtained made from that point on are fruits of a poisonous tree. Suppress the statement next. He definitely owes him an apology at Bless. And then there's another argumentative part at the next one too, with Steele and him and Steele and her, I'm sorry. Steele in love and Steele end up saying a comment and oh, it was kind of touchy too. It was very heated today. Seemed like do you think it's a full moon outside? Because it was really heavy in the courtroom today. Yeah, I know a lot about the Brady case. It has to do with them providing the other side with information pertaining to their case. They're not holding back, Coco. They're not holding back. Yeah, it was so quiet at this point in the courtroom. We just sat there trying to figure out what's going on, and then we went out for lunch. I just think the attorney just got to their boiling point with the judge constantly changing his ruling and making love happy. This is what T Girl says. Guys, make sure y'all hit the like button. It was a long, tedious, like dragged out. Then finally they said, okay, we can go to lunch. And then we came back and they continued bringing up Mr. Steele. He got ready to do a cross-examination, but there was some objection to him questioning Mr. Bean. And she wanted the judge to not allow him to question Mr. Bean a certain way, and she don't want to bring that in. And you guys gonna see that heated exchange between them. But it was crazy. So tomorrow we're supposed to get into court by 9 o'clock. It's supposed to start at 9, but it's gonna be 9-ish. And we go all the way till 12 o'clock. We're gonna take a break till 1 o'clock and then come back and be finished by 2:30. That's what he said. Between 2 and 2:30, we'll be out from court. So we'll be having a short day tomorrow. Hopefully we'll be able to be inside. Mr. Bean is supposed to come up. Hey, Michael, how you doing? The judge is going to end up calling this a mistrial. He's not going to have a choice. He's trying to help the prosecution as much as he can without being too obvious. Okay, she accused him of ethical issues. Yeah, it was back and forth. It was really, really ugly.
I'm gonna leave my original ruling as is, okay? So, Mr. Weinstein, if you would prepare a suitable order for my analysis, okay? Send that to Ms. Lowe and her colleagues, okay? All right.
Your Honor, we also have a matter of the issue that we addressed at the bench prior to leaving court the last time. The assumption of facts that had not been.
Hey, Mustafa.
Yeah, in fact, thank you for reminding me that. I was gonna ask you all, had you had an opportunity to determine whether or not Mr. Bean, in fact, was in custody, or not, was he in custody or was he at some point in time at the hospital?
So, Your Honor, there are two things.
Okay. Now, this is the one. This is the funny thing here. Remember last week, right? When, not last week, because it was like the week before, when Steele was doing a cross-examination, she made an objection. They went up there, and she was saying that that Mr. Bean never went to the hospital at the time or something like that. Remember that? Well, y'all, this is going to be the crazy part. Yeah, I know some of you guys have already seen it, but Mr. Steele was extremely detailed in every single spot of the transcript he was reading. And he basically caught her out there when she said that he didn't go to the hospital. He did. And there was actually someone did interview him, because he mentioned it as someone interviewed him. And yeah, you gotta kind of make sense, okay? This guy was just in a car crash accident, right? First place they would go is to the hospital, right? And most of the time, the police officer goes to the hospital to get a statement, because usually a statement's fresh in your head, especially if he's not like bleeding and unconscious or anything like that. They will go to the hospital and get a statement, because the statement is fresh in that individual's head. They will remember more things than later on, because they're saying that he went to the detective saw him like 6 or 7 days later. By the time 6 or 7 days later, the person's mind is not going to be as fresh as if it was when it actually happened, So I believe, this is what I believe. I believe they did go to that hospital and interview him. And supposedly that information, that recording, or that statement or complaint or whatever they file is no longer available. It was no longer available. You get what I'm saying? So it's no longer available. Any of us would be like, okay, how is this disappear? Why isn't he getting it? He said it in the on the recording that he went to the hospital. Okay, let's go ahead and play this.
Mr. Bean was, and I also determined that there were no statements that were made by Mr. Bean. So, Mr. Bean,
Okay, so let me ask the question directly. Was Mr. Bean ever at Grady Hospital?
yes, he was at Grady Hospital. He was held in Grady detention by two officers after he was arrested by Officer Faust on the 2012 warrants. So he was arrested for a different incident that had nothing to do with this incident, and he was kept for that purpose. No one talked to him, no one interviewed him, no one interacted with him about this case and the facts of the 2013 incident at all. There's no.
Okay, y'all. Did you hear what she just said? There was two officers that went there to arrest him because of a case in 2012. So it has nothing to do with the case that, the whole car smashing into the wall near the laundromat and all that. Had nothing to do with that. It said it had nothing to do with that, right? But they came there because there was a warrant from an old case back in 2012. There was a warrant out for him. So the officers came there just for that warrant. That's what they're saying now. Does that make sense to you? Do you think they'll come there for an old warrant, not handle the case that them crashing, almost hitting, killing a police officer? And does that make sense, y'all? Does that make sense?
None of that. Mr. Steele told the court that he had a good faith basis for asking the questions that he did, when in fact, the questions that he asked assumed and in fact put in the jury's mind that there was evidence that does not exist. So at this point, the jury will be looking for a statement from the hospital when there was not one made. No one questioned Mr. Bean at the hospital about this incident.
So then how was he at Grady medical detention? Was that a different incident, or was he actually at Grady?
He went to Grady detention. He was taken there by Officer Faust.
Okay, and is Grady?
He asked, what is it? Was it a different incident that he was in the hospital? Or was it this particular situation in 2013? Didn't answer the question. Deflected.
Grady detention at or on the campus of Grady Hospital?
Yes, it is a part of Grady Hospital. And what Mr. Steele represented to the court was that Detective Velasquez testified that.
Hold on one second, please.
They're waiting. Phone call. You hit the like button, y'all. Come on, guys. Get me in the algorithm. Hit the like. We have 199 folks up in here. Can we get to hit the like? Come on. Bless your sister with a like. Yeah, when I tell you it was heated, it was so freaking heated in that courtroom today. Y'all, you could have cut it with a knife, how heated it was. Only 66 light with 201 people in here. Wow. 66 likes. Can't even get 100. No, tall glass. I didn't see it. No, I did not see it. I did not see that. We got 75. Can we get at least 100 people? Can we get at least 100? I got to see that one, Tall Glass. Okay, I'm gonna move forward a little bit because
References prior conversations that he has had with Mr. Bean. So
okay, I had to get it over a little bit. Yeah, I guarantee you, one of these defendants is gonna end up being a lawyer. One of these defendants is gonna be a lawyer. Watch, mark my word. I'm telling y'all, one of these defendants is gonna end up being a lawyer.
All right, so we were talking about Mr. Bean, and there's a detention facility that's actually at Grady Hospital, correct?
there he is.
All right, is that what Mr. Steele was referring to, or could it be that he's referring to that?
Your Honor, this is the issue that I have with what Mr. Steele is doing, and this is what 24-1-103 prohibits. Specifically, 24-1-103, as the court is aware, states that jury proceedings shall be conducted to the extent practicable so as to present inadmissible evidence from being suggested to the jury by any means, including but not limited to making statements or offers of proof or asking questions in the hearing of the jury. So when the state has been making the objection that the questions Mr. Steele is putting upon the witness assumes facts that are not in evidence, Mr. Steele has responded by saying he has a good faith basis, but instead what
Well,
he
the
is
court
doing,
asked him that, and he can ask the question if he has a good faith basis, meaning that he cannot misrepresent or lie to the court about Mr. Bean's whereabouts. So I wanted to make sure that was kind of not occurring. So I understand what a 103 analysis or inquiry allows the court to do. So is it your opinion? I just want to ask you a question. Sorry to hijack you again. Is it your opinion that the conversation about Grady is not appropriate because it was at Grady detention or in the hospital?
no, my assertion is that Mr. Steele's questions go something like this. Why did you tell Detective Lewis at the hospital that you were not driving? He also
Is that
asked,
Grady detention though?
yes.
Okay.
But wait a minute, Your Honor. This just it. His question, why did you do that, assumes that the witness did that. And there is no evidence that the witness did that.
Well, it needs to be rephrased.
And Your Honor, he also 28 times has asked, when you talk to your wife on an unrecorded line at Grady Hospital, there's no evidence that he did that. There's no evidence that will come in, and there is no evidence that Mr. Steele can bring to the court. And if he does, I would ask that he proffer it, because I listened to the information, to the recording that Mr. Steele gave us at 6 o'clock that day that he presented, that he cross-examined Mr. Bean. And he asked a plethora of questions that are nowhere in that recording. And he is doing it on the basis that he is confronting him with his prior statements. But the problem that I have is this. In that recording, Mr. Steele references prior conversations that he has had with Mr. Bean. So in an effort to discern what he's talking about or what information Mr. Steele may have fed Mr. Bean or what happened, I asked the witness, who is also on the recording, I called him up and said, I'm trying to find out how many times you all talked to Mr. Bean, what did you say, and whether there were any other recordings. The witness, Mr. Steele's investigator, told me, I'm not comfortable talking to you without Mr. Steele. I won't talk to you without Mr. Steele. As a matter of fact, no, you may not call him while we're on the phone. I don't want to hang up on you, but I will. And this goes to privilege. I said, I'm just trying to discern how many times you all talked to Adrian Bean. so that I can have information that I'm entitled to. He would not give me any information. So I called Mr. Steele. Mr. Steele didn't answer. So I wrote Mr. Steele asking for how many times you talked to Adrian B. Give me the other recordings. Give me what you have. He did not respond. I called Mr. Steele. I said, Mr. Steele, how many times did you talk to Adrian B? He tells me, I'm not going to answer that. What you're doing is somehow unethical, and we'll take it up with the court in the morning. I said, okay. So, Your Honor, the problem that I have is, one, Mr. Steele is improperly suggesting to the jury, planting in the jury's mind that this witness made certain statements to the police at the hospital when he did not. Mr. Steele doesn't have any evidence whatsoever, any statement. He doesn't have any recording. He doesn't have anything. He has not asked the witness. He has not done anything to present a statement at the hospital by this witness, and certainly not one to Detective Tracy Lewis. So Mr. Steele tells the court that his good faith basis for asking the questions that he is asking is that he is confronting the witness with the statements that he made during the recording that Mr. Steele provided the state on last Monday. When in fact, the information that he is asking, he is not saying, did you talk to Detective Lewis? Or you talked to Detective Lewis, didn't you? Instead, he's saying, why, when you talked to Detective Lewis, did X, Y, and Z occur? And that in itself is exactly what this rule is designed to prevent, Your Honor. Because unlike asking the question, it's sort of like asking, did you mean to beat up your wife when you hit her in the head? When there's no evidence that the wife was hit in the head or that the person on the stand actually did it. So under 24-1-103, 24-6-6-11, 24-6-6-23, the state would ask that all of these impermissible questions be stricken and not allowed. So when he is asking these 28 times, why did you do
I'm gonna
this?
I'm gonna go forward to Steele's part so you guys can hear what Steele says, and then I'm gonna go to where the judge is arguing with Steele. All right, hold on. I know some of you guys have seen this early.
Transfer page 5, lines 20,
He was very detailed.
starting line 20 through transfer page 6. District Attorney Love, answering your question, nothing shows that Mr. Bean went to the hospital.
See, you hear that?
District Attorney Love on transfer page 5, line 24 through 25. Mr. Steele is misrepresenting that to the court, meaning that he was taken to the hospital. Transfer page 6, lines 1 through 5. District Attorney Love states Mr. Bean went straight to jail and that the district attorney has the documentation, the printout. I asked to see it. I was never shown it because I didn't believe it to be true. And I'm going to tell you why I believe it wasn't true to answer your question fully. Transfer line 7, page 4 through 5. I have no good faith basis to ask this question. Ask this question is my words. Transfer page 7, lines 6 through 9. District Attorney Love said that I have nothing of either Detective Quinn saying, I'm recording, hey, he went to the hospital. District Attorney Love stated to this honorable court, continuing to tell you that I misrepresented intentionally. Page 7, lines 10 through 24, that I assume things, nothing on the tape. Mr. Steele, this is a quote, put that in there, end quote. Mr. Steele knows it did not happen. Mr. Steele is manufacturing evidence.
Hey, Diego.
On page 10, you asked
Dango.
you advised us on line 20 through 25. The issue is whether Mr. Bean was taken to the hospital, whether Mr. Bean made a statement at the hospital, and on line transfer page 11, lines 9 through 10, District Attorney Love again. Adrian
Okay,
Bean.
Mr. Steele is basically pointing out from the transcript a couple of weeks ago what DA Love had stated. Basically she was calling Mr. Steele a liar because she was saying that Bean Mr. B never went to the hospital, and that, so now he's showing every single part of the transcript from 2 weeks ago of what was said and what is being said now. See, now she is changing, saying that he went to the detention center at Grady. Detention center at Grady is still Grady, because I went to the detention center, y'all. It's like the bottom part. It's like the first floor of Grady, and it's like where they take people who's been arrested, because they put a handcuff on you on the bed, and everything's like metal. Even the bathroom, they don't have like regular closing door, they have like sliding doors, somebody can open it up and stuff like that. Because the funny thing is, I got a chance to experience some of the stuff that's going on, so I could give you firsthand what this place like. So the detention center, because I got sick when I got arrested. The detention center is right in Grady on the first floor, and it's like, it's like a room. They take you back, and you can't run out if you want to, because you're supposed to be arrested. And there's police officers that sitting by the door where you are, and they have you handcuffed to the bed, and you can't go anywhere. Okay, so I'm just going to give you my little personal experience of being in Grady Detention Center, which is where I was at. Say no more. Okay. Yeah, I was really all right. I was just giving you guys example where it is. It is in Grady. It's in Grady Hospital. It's just the first floor of Grady Hospital. And it's way in the back part. Okay.
Never went to the hospital. So I knew that was all wrong. But, when a lawyer says something like that, maybe my information is wrong. I'd like to see the documentation. I don't get anything. So, Your Honor, and it's in evidence. If it's not, I'd like to put it in evidence.
That surely was. I green.
The reason I believe that he went to the jail, not straight to the jail as being told to you, is that in discovery, the following occurs.
So, guys, I can tell you firsthand experience on this.
And I'll mark this as Mr. Williams' exhibit number 202 with the court's permission. It can be played for the court. This is the file. It was given in discovery by the state of Georgia to Mr. Williams and all. This is the police radio traffic. You heard some of it during the trial through the witness who identified the radio traffic. It starts at 0054. This is Z radio, 1231 hours through 1300 hours, so 1231 through 1 o'clock. And it reads, down here on Cleveland Avenue, start us of 4. That means ambulance, Your Honor. You heard that through the testimony. For a 34-year-old black male with injuries to his shoulders, head, and to his back. If you remember, Mr. Beam was born 6/22, 1979. That would make him 34 years old on September 11th, 2013. It says, okay, Cleveland Avenue, Old Hayfield, 122, Cleveland, and that ends at 112. At 1300, Major, where do you want me to bring the bus? Meaning the ambulance. Oh, come up here to Cleveland and Old Hayfield. Take a right. I'm standing here. I'll direct you in. That's at 1314.
Okay.
1602.
Okay. That's the radio thing telling you going to the hospital.
Avenue, Old Hayfield. I got a perp in the backseat of my car. That's at 1607. It ends. At 2808, 2308, I'm right in the parking lot. Tell them to come down Cleveland Avenue. I'll get them. I'm in the parking lot with the coin laundry. All right. Trying to get Grady to find you. Right.
So that was the ambulance.
It's unintelligible for my notes. I'll get out of the car and flag him down. It's at 2028.
I see.
Then at Mr. Williams, I'll mark it exhibit number 203, Your Honor, for purposes of this, or I'll play it for the jury. File Z radio, it's 1301 hours through 1330. So that's 1:01 in the afternoon to 1:30 in the afternoon, same date. September 11, 2013, 1842 on the recording. 13 radio following Grady Unit 320 down to Grady Hospital. 1848 at 2736. Are you en route with another victim? We en route with another suspect. The other suspect, okay, I copy that. He's 1050. Also, that 1050 is a shot. Says, I don't think so. He's going to be in custody. He's in 83. 83 means another warrant. Mr. Bean at that time had a warrant for the year before for shooting 2 people. You heard that impeachment. He pled guilty to that. He received before the Honorable Judge Downs 15 to do 3. Okay, so why not bring him to Grady? Excuse me. So why not, bring him to Grady? Isn't he injured from the crash? He's probably going to be injured, Sarge. That's why they've taken him to Grady detention. So probably be injured. Okay, copy.
You went straight to the
He was the guy
hospital.
that was hit by the car, question mark. I don't know which one the guy he is. This is the one that AC, meaning you heard from AC Booker Higgins, officer, and them got over at the Barber Institute. That is Mr. Bean, in fact. Yeah, that's affirmed at 2836. Then I'll mark it Mr. Williams, Exhibit 204. It's file Z radio. It's 1331 through 1400 hours, so it's now 1:30 to 2 o'clock. 2820, raise 2013 and have them go over. We got the 83. That's Mr. Bean down here at Grady, and that's at 2827. So I knew he was at Grady when Miss Love was making these representations that I'm misrepresenting. But, you know, I don't find lawyers to do that. Then, Your Honor, there is a recording, and it's at 1949. We can play it for you. It's Detective Quinn and Mr. Bean. So it's 6 days later. So it's now the 17th of September, 2013. And Mr. Bean is being recorded the whole time by Detective Quinn. And Detective Quinn states as follows.
He's very detailed. Steele is not playing with them because they call him a liar. He's going over to his the table to go get the rest of his folders. When I tell you this man was so detailed in this, it was.
At 44:56, actually.
In what, sir?
This is September 17, 2013, recorded interrogation. Detective David Quinn, now retired, with Mr. Bean. And I'll play it for you if you'd like. But Adrian Bean states as follows. Yes, sir.
Hey, bro,
I lied
nosy.
to the detectives when they first came and talked to me. And I told them that's probably the lies that you're talking about. Detective Quinn then said, okay, what did you tell them? Adrian Bean, I told them Big Fred was driving. So we're sitting here. I have zero information on when Mr. Bean spoke with detectives. But I do know this. Mr. Bean told me that he spoke to detectives at the hospital. Detective Calhoun testified before the court, went down to the hospital, spoke with, it's on recording, Fred Prethrow. Fred Prethrow was asked, what happened? Who was in the car? Fred Prethrow said, DK, Adrian Bean, and me. 3 occupants, 3 occupants. It's on recording. Detective Lewis goes and speaks with DK, who is known as Mr. Walter Murphy. I have no recording. I have
No recording of whom?
Detective Lewis at the hospital, Grady Hospital, September 11, 2013, meets with Walter Murphy. And Your Honor, as my eyes roll out of my head, I'm about to show you why I do not believe the City of Atlanta Police Department at all. This is served in discovery. I will mark it Mr. Williams C and D. And then you tell me if I'm supposed to believe the allegations from the state of Georgia.
And Your Honor, while Mr. Steele is pulling that up, I am reiterating that his failure to believe or not believe is not a good faith basis for asserting facts that are not in evidence.
Well, let him finish and I can kind of have another conversation with y'all about it, okay?
Madam President.
You may, sir.
For purposes of motion, I am handing the court what I was provided in discovery by the state of Georgia. I made it for today's date, Mr. Williams, Exhibit C, as in Colette or Charlie, and D as in Delta. And if you will see and take note, on the top, it's the City of Atlanta Department Supplemental Incident Report, narrative only, page 1 of 1 on both C and D. Your Honor, the incident report is exactly the same, 13-254-1308. The complaint name in both are left out. The date of the report is the same, 9/17/13. It says reserved, and nothing's in there. It then has a narrative section with an affidavit. Your Honor, the first paragraph has Detective Lewis going to, the two people going to the hospital with injuries. Investigator Calhoun and myself, Investigator Lewis, went to Grady Hospital. If you remember from the testimony, Investigator Calhoun goes and meets with Mr. Plethro, 3 people in the car. Investigator Lewis goes and meets with Mr. Murphy. Investigator Calhoun recorded it. I have this report on Investigator Lewis. Next paragraph of C and D are identical, Your Honor. Once we arrived at Grady Memorial Hospital, there were 2 males being brought in for gunshot wounds. I was advised by the Grady medical personnel were not life-threatening. We could speak with them once they got stabilized. It's going to be identical. The next paragraph, Your Honor, the first 2 lines. The first line, I spoke with Walter Murphy in C, gives a date of birth, 8/9/91. He had sustained a gunshot wound to the left thigh. It's going to be identical. Then it starts, he advised that. In C as in Colette and Charlie, but in D, it says, he advised me during the. Then D is whited out. The entire part is now vacant. C goes on to say that that the other three males, now there's three people in the car, one named Bean, drove to the laundromat on Cleveland Avenue to meet up with another male to sell an ounce of marijuana for $450, and it goes on. Your Honor, at the bottom of C, it is signed, same looking signature of Investigator Lewis, I presume, on 7 reporting officer's signature. It is also signed similar on D, Mr. Williams D. The APD number is written in on D, but it's typed in on C, and it's the same ID number, 3081. As far as section 9, which is in the center on the bottom, it says sworn to and subscribed before me the 17th day of September 2013 in type on C. D, it's in writing. And then on the bottom, it says supervisor's signature, and a supervisor actually signed off on C, which is supposedly a complete report, as also D, which is clearly whited out. In addition to that, Your Honor, on both C and D, there is a statement at the very bottom before the signature, above the signature line, the undersigned being duly sworn upon his or her oath deposes and states that the foregoing is true, correct, complete, and legible to the best of his or her knowledge and belief. So when I sit here and I hear Ms. Love tell me how diabolical I am and how I don't have a recording, or I don't have a statement, or I don't have a note or a summary or a writing that Mr. Bean was interviewed at the jail, at the detention center after Ms. Love told this honorable court total misrepresentations. I don't know, I assume that she had a good faith belief, because that's just what I do with lawyers. But she attacks me like I'm out of my mind when this is in the discovery. This is all, she knows this. And then I'm giving C and D, which is clearly going to come out before your court, because if the state doesn't call Investigator Lewis, I'm calling Investigator Lewis. Because this is what I would say is corruption. Because I don't see this often.
Do we know why
Right.
why one statement is incomplete and the other one is?
And why I have no recording, and why I only have this on the 17th day of September, and why Detective Calhoun's is all in recording and a report on that day, and why is it that Adrian Bean tells Detective Quinn, when I first spoke to the detectives, I lied to them about Fred Prethro driving, and why is Adrian Bean telling me, yeah, the police wanted YoungThug, Jeffrey Williams, whatever the words are, involved in this case? And why is it that Adrian Bean is on a jail call with his wife? It's the next day, it's September 12th of 2013. And his wife says on that jail call, the homicide investigator, it's going to be Detective Quinn, came by a second time yesterday. That's the date of the incident. And he told me that the driver, people think the driver's a woman wearing a wig, but it's really a man. It's a boy. And Detective Quinn is giving this information. And whoever the driver is in big trouble, but if Mr. Bean is a passenger, he may not have any charges. And on that same recording, Adrian Bean is telling his wife, they gave us a story to tell. And Adrian Bean tells me with Investigator Martin that that story to tell happened at the hospital. Now, he blames it on Detective Quinn. It's also 10 years before, so maybe it's not Detective Quinn. I'm not saying it's Detective Lewis. My questions were, or some detective. But his point is, it's a detective that introduced Jeffrey Williams to this. And then you could go through the crime, which I'm going to do, the crime scene photographs. There's not room for 4 people in the back of the car. In addition, there's no shooting in that car. Like the police did it and they cleared, and I'm not saying Robert Sinell was not justified. I am not saying that. But Robert Sinell discharges firearm multiple times and it crashes through the very rear window on the passenger side of that 2004 Nissan. Those bullets go somewhere. Mr. Murphy is shot twice, one in the lower ankle in his right leg and one in his left leg, upper thigh, which strikes an artery. That's why there's so much blood from him. Fred Plethro is shot through the headrest. Now just imagine a 6'3" young man sitting in the ways of those bullets. They can't get around him. There is no one else in the car. And the state is blaming me for this. This is outrageous. And I can ask every single question the way I ask it, and I ask it properly. And Adrian Bean, for all that he's worth, the jury makes a determination. And what Ms. Love is trying to do is obstruct the truth from coming out, because she knows all this. That's why last time I was a fibber for telling the court that he went to Brady Hospital. When she realizes it's patently true, now I'm a fibber because no one spoke with him. And I'm just supposed to believe that these officers took him down and they had him on wraps and no one spoke with Adrian Bean. I apologize to the court. That's also a jury. Juries make those determinations. In addition to that, this case should be dismissed. This is outrageous. I'm going to do that once I get it into evidence before the court, but I'll do it now since it came up and Ms. Love is attacking me. And this evidence is wrong. I also ask continuously for all these videos. I don't get it. And then months later, I'm getting a video on the shooting at the movie theater, which I know you don't know about yet, but it's about Christmas of 2000, maybe 15. The point I'm trying to make to you, Your Honor, is this is a moving target by the state of Georgia. And no, to say that I have no good faith belief because I can't show this honorable court where these statements are, that's my point. It's Brady evidence. This is all Brady evidence. And if this happened in another forum, the state bar, I'm not doing that. I don't report people. I believe in people and lawyers. I don't know what Ms. Love is doing, but to attack me on misrepresenting to this honorable court, I have never done that. I will not do that. And I will never, ever do it to any court. That's not what we do. But I also understand my duty is to make this process rigorous, zealous, and I am going to fight for Jeffrey Williams in every lawful and ethical manner the entire time. And that includes destroying Adrian Bean's testimony and revealing the truth. In addition to that, Your Honor, the state of Georgia calls our investigator and wants to know dates and how many times we supposedly met with Adrian Bean. That is work product. That is not a statement. That is not covered in any type of work product, and this is not my witness. So when you ask the court and you never got the answer, but OCGA section 17-6-4B as in Barry, Bravo. May I approach, Your Honor?
You may, sir.
All right, this is 17. I've handed this honorable court, the Honorable Mr. Kearns, and the prosecution of the Honorable Madam President, District Attorney. 17-16-4B1. It's on page 3 of 5 of the copy I've given the parties. It states the reciprocal discovery, which Mr. Williams did opt into. B1 towards the center but top of the page, it states the defendant within 10 days of timely compliance by the prosecuting attorney, but no later than 5 days prior to trial, or as otherwise ordered by the court, shall permit the prosecuting attorney at a time agreed to by the parties or as ordered by the honorable court to inspect and copy or photograph books, papers, documents, photographs, tangible objects, audio and videotapes, films and recordings, or copies or portions thereof, and to inspect and photograph buildings and places which are within the possession, custody, or control of the defendant, and this is what I stress, and which the defendant intends to introduce as evidence in the defense's case in chief or rebuttal at trial. I am not in my case in chief. This is the state's case in chief. I'm on cross-examination. On 17-16-7, which is the other copy I've given this honorable court, and the parties, our legislature wrote, no later than 10 days prior to trial or at such time as the court permits, or at the time of any post-indictment pretrial evidentiary hearing other than a bond hearing, the prosecution or the defendant shall produce for the opposing party any statement of any witness that is in the possession, custody, or control of the state or prosecution, or in the possession, custody, or control of the defendant or the defendant's counsel that relates to the subject matter concerning the testimony of the witness that the party in possession, custody, or control, and this is what I stress, Your Honor, of the statement intends to call as a witness at trial or at such post-indictment pretrial evidentiary hearing. I am not the person who intended to call as a witness at trial or any such post-indictment pretrial evidentiary hearing, Mr. Bean. The state called him. I don't have to, by law, give anything to the state that I did, and calling a person under the umbrella of the attorney-client privilege and asking to give over information is unethical. When Ms. Love asked me yesterday, I was very polite to her, but I told her I feel like I would be contributing to your unethical and unlawful conduct. I will not speak with you about this. In addition to that, Your Honor, you heard Detective Velasquez testify that he, at times, destroys recordings. I have never heard that before. You heard Detective, who's a female, Benton, say that that is a crime. You heard a witness, Mr. I'll get the name, but he's the one who had the car from his girlfriend, say, Nava Flores, thank you, say that he made a statement to Detective Quinn, and that statement was then erased, deleted, whatever his word is in the transcript. That's what I'm dealing with. And this is all taken together. In addition,
Okay, guys, I'm gonna move forward to when they get into a spat and with the judge, and I am going to I'm gonna go to bed because I gotta get up in the morning. Hold on a second. Hold on. Let's see if
I know what you explained, but just explain again what truly happened. I know you took a break.
I don't even know when we went in the court. Me, Ross Murphy, and I think one day we come to court and it said, case dismissed, that the victim had killed himself or something like that. So I'm like trying, you don't got a victim.
I'm talking about your other case. Well, you went to, yeah.
But that had something to do with my children. They ain't got nothing.
But your children
were no
explain what happened.
What happened with my kids was I had a pole rock. You had a 10-year-old and a 12-year-old that was choked. And one of them punched in the stomach. It was my kids. And I went around there and covered with the guy and caught him by myself. And I got caught up in it, and I explained to the judge what happened, and the judge sentenced me to 10.
And you caught up with the person did you get?
Yeah, I shot both of the guys that, in the mix.
And how old
going on there. But the one was 28, and the other one was 31. They were shopping on a 10 and 12-year-old. That's what I go in the neighborhood. this was my kids. So like everything that went on me, it happened to me and my kids. You know what I'm saying? It had nothing to do with none of that.
And then last thing, and I'm sorry that you went through that and your children. YSL, are you ever part, they're saying YSL's a criminal street gang. Are you ever part of a criminal street gang?
Judge, the defendants exhibit 1 and 2, or C and D, or whatever he called them.
What I think that the question assumes is that he did in fact talk to Detective Lewis, and he didn't.
I don't know if that's true.
Well-
I'm not conceding that.
Well, I'm going to tell you that I haven't heard anything that would indicate that's truth.
Yeah, well,
That you have a good faith basis to ask that.
You haven't heard anything of who he spoke with. That's my point.
That's the point.
He spoke
But
with
you
somebody.
all can't. But you two, neither one of you can proffer that.
Judge.
It's not proper, Mr. Steele.
No. Listen.
It's not.
Let me finish.
It would be a violation before me for you to put that in front of this jury.
You're not letting
He
me finish.
did.
In the September 17, 2000.
You are saying to the court that you have a belief that there is another statement out there. There's not.
How could you say that?
Because it hasn't been brought up. If it gets brought up, then we'll correct it at that point in time. But right now, I'm going to direct you not to inquire that line. You don't have a basis to do so.
Not true.
Well,
It is-
go ahead and make a statement and see what happens.
Your Honor, listen. It is-
Go ahead and make the statement in contravention to what I've just told you, and I'm telling you that you will have some problems in front of me.
I'm trying to articulate to you.
You have told me everything at this point. You have told me that there's got to be a statement. Now, if you find the statement, I will, one, apologize to you. Two, I will take corrective action. That's probably not going to be nice to anybody. But at this point, there's nothing for me to do other than if you don't have a good faith basis to do it, you can't ask the question.
Your Honor, listen. There is a recording between Detective Quinn and Adrian Bean where Adrian Bean says, I lied to your...
But we don't know what he lied about.
He says he lied about who... He's talking about the car.
But we still don't know whether or not he had a conversation with Detective Lewis.
And I made it clear. It's 10 years ago.
But you said you had, in your conversation with Detective Lewis, that's what you proffer.
I said, or any other detective or law enforcement. Read the transcript. I made it clear. I don't know. He doesn't remember names. He says it was Detective Quinn. Also on the recording, on Sunday, January 22, 2023, Mr. Bean is the one who said this happened in the hospital. Your Honor, I'm the one complaining about I don't have the statement. I've been asking for it. This is Brady. Clearly there was a statement made.
We don't, but we don't know if there's a statement. You're supposing there's a statement, okay? And there may be. And you know what I said? And you know what I said earlier? I said if there is Brady that's not disclosed, then that particular individual is going to have some problems with me. I told you that already. Or I have a lot of different remedies I can execute at that point in time.
There has to be. That's why I gave you the
But you can't intimate or otherwise cross over the line when you don't have the statement to back it up.
Judge, I've been robbed of the statement.
But we don't know where the statement is. If we find the statement or it comes up or in cross-examination, Quinn brings up and says, hey, I have a statement right here in my massive file. And if he does, then of course I will revisit this particular subject again.
I'm saying it's been deleted. It's been destroyed.
We don't know. You don't know. We don't know what happened. We don't know what happened. We had the same issue that happened earlier in this trial about a statement. We don't know whether or not it was the hack or whether or not it's intentional. Now you can make whatever hay you want out of it. I mean, and the jury can decide for what they want to give it. But you cannot ask the question in its current form. You just can't.
Your Honor, I'm not asking any questions, but you have to understand the following, please. 6 days later, Detective Quinn and Adrian Bean are on recording where Adrian Bean tells Detective Quinn, I lied.
About what?
I lied.
About what?
Who was driving the car. He gets cut off. Detective Quinn says, yeah, tell me about it. Where's that statement? That's what I've been asking for.
Well, but that doesn't still give you the latitude at this point in time to ask that question. Now, I told you, if we find out from Quinn, and I'm telling the state that if I find out that the statement exists, there's going to be a lot of unhappy people.
Well, what if you don't find out it exists? I still am entitled to. That's my whole point.
Okay, but here's the thing. You've asked me for it. I've asked them. If it comes up later, or I find out it's sitting someplace that was in possession of the state, pursuant to case law and definition, then we'll have some problems.
I understand, but you're asking where you have to find the statement for. I'm telling you the statement was made.
It doesn't work that way, Mr. Steele. I'm sorry.
It does work that way.
No, it does not.
Yes, it does.
No, it doesn't. And you haven't presented any case law to tell me how to do that. And I'm telling you, as the judge presiding over this case, if you do that, it's misconduct.
I'm not doing anything.
I'm telling you right now.
I don't know what you're telling me. I'm not.
I am telling you, you have no good faith basis at this point in time to ask that question right now, or to intimate that.
I didn't ask any question. You are listening to District Attorney Love. I'm ready to cross-examine. I'm going to play the recording you just heard. This gentleman tells me on recording that he was at the hospital speaking with law enforcement. I want that. It is backed up because on recording, 6 days after the crash into that side of the building, Your Honor, Detective Quinn and Mr. Bean are talking about the statement that Mr. Bean made prior. I don't have it. And when the court asked me, well, you got to find it, or if I find it, it wasn't given over.
Then we'll have some problems. Then we'll have some issues.
I have some issues now. I've been begging for it. The state's supposed to give this.
Let me ask, hold on, Mr. Okay, stop for a second. Ms. Love, have you inquired of Detective Quinn where this other statement may be?
Judge, that's just it. Mr. Steele is literally manufacturing evidence. There is no other statement. I have asked whether or not there was a statement. I asked Tracy Lewis at the hospital. Let me be real clear, because he keeps conflating stuff. Adrian Bean never told Detective Quinn that he made a statement at the hospital. I have his transcript.
Okay, but we don't know where he made the statement, and also he's lied. So we don't know what he lied about either.
Your Honor, to be very clear, there's no statement. I have asked Detective Lewis. They can ask Detective Lewis. She never talked to him. Okay. Detective Quinn, who is the only person, it's not just police, the only It's obvious that he didn't speak to Detective Quinn at the hospital, because the first time he met Detective Quinn was September 17th, when he pulls him in for the interview. Literally, Mr. Steele is manufacturing something. So when the court is even asking me, okay, do you know where this statement is? Assuming that there's not a statement. There is no statement. There's no evidence. That's the problem with Mr. Steele asking questions the way that he asked them. He is assuming facts that are not in evidence. And he is usurping the jury's province and their ability to discern and weigh evidence, because he is injecting assertions into his questions about things that don't exist. Similarly, he says, do you recall explaining that you made calls from the Fulton County Jail that you knew were being recorded to support your lie to the police that Jeffrey was involved on September 11, 2013? That's what he asked the witness. You heard the interview. He doesn't say that anywhere in that interview. This is the kind of manufactured evidence Mr. Steele keeps putting in front of the jury. He never said that during the interview, yet that's the question. That's the question Mr. Steele asked Adrian Bean on the stand. Nothing like that ever happened. And during his cross-examination of Adrian Bean, the cross-examination is replete with examples just like that. There is no statement. He can't sit there and say there has to be a statement and then ask the question as if there is one, because that's improperly asserting to the jury something that isn't factual. There's no evidence of it. So to answer the court's question, of course we have asked who spoke to whom. Did Tracy Lewis, did you speak to Adrian Bean? I talked Tracy Lewis, I talked to Walter Murphy, and I put it in my report. I made a report of that. Calhoun, did you talk to Adrian Bean? I talked to Frederick Prothro. Here's my recording of that. Detective Quinn, and then this idea of destruction of evidence, that is the fallacy that is getting thrown around. That's the problem with asserting facts not in evidence. That's the problem with them being allowed to ask those kind of questions. Do you destroy evidence? Nobody has said anyone destroyed any evidence. Eduardo Navarro Flores said he heard that Detective Quinn had erased the interview. Well, then why all throughout Detective Quinn's report does he refer to the lie that Eduardo told in the first place? How is that destroying evidence? But they're trying to create a narrative for the jury of things that don't exist, a narrative that somehow the state destroys evidence. There's been no evidence, no suggestion that the state has destroyed any evidence, but they're going to ask it a million times. So that's what Mr. Steele is doing with this whole statement at the hospital. He's going to ask it a million times. So the jury's sitting there going, well, where is it? And then in the end, $100 says that he gets up there and says, they destroyed the statement from the hospital, knowing he has no evidence that one even exists. With Detective Lewis, and certainly not Detective Quinn, who is the only person Adrian Bean tells Mr. Steele, at least in the portion of the recorded interview he gave me. I don't know what else he told. I don't know what Mr. Steele told Adrian Bean, but it's obvious that he's leading him through the interview that the court heard. And even being led, Adrian Bean does not let up on his assertion about Detective Quinn. Mr. Steele tries to get him to change it. You mean somebody else, other police, no, just Detective Quinn. So this idea that he has a right to ask questions that assume things that are not in evidence, that he has not put in evidence, that he cannot expect to be put in evidence is ludicrous. And to assert that the state is trying to hide something because he wants to taint the jury's mind, taint the fact finders with falsehoods, and somehow, I guess that's the way he wins cases. I don't know. But, Your Honor, I'm just...
Oh, that was a low blow, y'all. That was a low blow. She said with falsehood, maybe that's how he win cases. No, man, that was throwing some shade, y'all. That was shade being thrown. Oh, my goodness. She threw it first, y'all. He gonna come back. Watch.
The number of times he asked Adrian Bean questions that assumed facts that are not in evidence.
Shot fired. Yep, Kim, shot fired.
Just staggering. It's just staggering. I'm simply asking that Mr. Steele be precluded from asking those kind of questions. And Your Honor, I'm asking that any reference to statements made at the hospital in the manner that he has asked them, that assume that there was one, be stricken, and that the court instructs the jury that there is no evidence of any statement made at the hospital to a Detective Lewis. And then let them weigh whether or not a statement was given to Detective Quinn. But that's not the question that Mr. Steele asked.
Uh-oh. She sit down. Okay. He's about to sit down, y'all. She's sitting down. Okay, let's see what happens next. All right, let's I want to get the dead space part here. Okay, let's see. All right, he asked him to play. Okay, this is when. Okay, this is when there was an argument on whether or not who brought up the part of whether or not he was in the hospital, and this is Bean is getting ready to tell that part about being in the hospital where the interview was done at the hospital. Okay, that he spoke to an officer in the hospital. Listen closely.
Stop.
You're in the what? I was in the
Stop.
hospital.
Stop.
He said he was in the
Mr. Dean
hospital.
says we were in the hospital.
Yes, Your Honor, he said that we were in the hospital. He doesn't say that he was, that one, that he gave any statement to Detective Lewis at the hospital.
But that goes to weight. I mean, that goes to weight and sufficiency and what the jury wants to believe or don't believe. I mean, it's clear from the state, it's clear now from listening to the tape again that Mr. Steele, that was not a production or a product of Mr. Steele's questioning. It was the witnesses saying.
The witness
hey,
said it.
Judge, I
He was
think
at the hospital.
it was after that, because Mr. B, when he's
Oh,
talking,
she wants
he's
that
saying
30,
we're in the hospital.
15 seconds after.
That's what he's, but if the court will just listen to.
Okay, give me another 15 seconds.
15 seconds, he gonna play
You
it.
know what I mean? When shit happened. So it's like they push in and I was up there. I'm the victim. I don't know what's going on. So, yeah, as far as case, accident. Right. You know, the car, they say. We crashed. Yeah, careened over a police car and into the side of the building. Right. And you were driving the car. I was the driver. Okay. And they even said, so I say he the driver. Yeah. You know what I mean? So the police wanted you to say you had to get out. But that's what he done so, but not in the vehicle with us. Did he have anything to do with it? Yeah, nothing to do with none of that. Can't no man, I'm 42 years old, can't no other man tell me what to do. Can't no other man make no other man tell no other man what they need. Everybody wrong. So why did you tell the police this on recording that Jeffrey Williams was involved in this armed robbery because the police told you to say that so you get out of trouble? Is that the reason? Yeah. Okay. Now you're also on another show called the one I'm going to send you. That's the one I want to hear. You know, I'm going to send it to you. But for what you say, the reason you would have.
And so, Your Honor, when Mr. Steele says, do you remember the detective asking you questions about the incident involving the armed robbery of Mr. Dotson and almost killing police officer Robertson L and striking the other police officers, and careening over the embankment into the wall and fleeing? Do you remember that? He says, no, sir. Then the question, do you remember telling that detective, specifically Detective Lewis, at that time, there were 3 people in the Nissan red Altima vehicle? That's nowhere in this statement. What Mr. Bean is doing at the point that the court just heard, he's saying one thing, and then he's saying, you know, we were in the hospital over there. We were like victims. We were laying there.
Okay, but he's got a good faith basis because he's got a couple of different sources. He's got this interview.
Yeah.
He's got the let me get to it again. Hold on one second. He's got Williams 203, which is the radio traffic. He's got Williams 202, which is radio traffic, and he's got the interview of him and Detective Quinn, Williams C and D. So so if he's got all those things, Miss Love, he's got a good faith basis to ask those particular, you know, because they're different source documents, but it doesn't take away from his ability to ask those questions because they are in fact things that elements or not elements, but information he has that he can test.
Your Honor, what I'm saying is, in order to say something like, do you remember telling Detective Lewis at the time there were 3 people in the Nissan red vehicle? That when he says, do you remember? It's assuming that happened.
Oh,
he hasn't shown that it happened. He hasn't played anything. He hasn't laid a foundation for impeachment for that. He has nothing to say that happened. So he can't come back and show evidence of it. He's just saying it. Okay. And there's no evidence of it. He can argue it at the end, but he cannot put questions on a witness that assumes things that are not in evidence. And furthermore, when Mr. Steele is talking to him about the information, when he says the jail call, this is the killer. When he says, the part that the court just heard, I played you a recording a while ago. I promise you I'll email you the second one. The one I played for you has you and your wife speaking at some point around the 11-minute mark. They gave us a story to tell. What does that mean? And then Mr. Bean says, I don't know again what they talked about off recording. It's like they said put Thug in there. If you listen to this recording that they're talking about, Mr. Bean, and it is clear as day, Mr. Bean is chuckling with his wife over the fact that Walter Murphy and he said to the police that they're the victims. And that's the story. He said, I'm glad them boys kept it 100. I'm glad they kept it solid because they gave us a story to tell. Both Walter Murphy at the hospital said, we were getting robbed. In this jail call, Mr. B to his wife says, I told him, we were the ones getting robbed. That's what he's saying, and it's disingenuous for him to sit here and say, who told you? What did they mean? Was it the prosecutors, the police? Who told you that? Detective Quinn. No other prosecutors or police? No, Detective Quinn. And then when he says, we were in the hospital. I was in the hospital when that shit happened. We were the victim. The court heard him say it. Adrian Bean talks like this, and I would ask that the court allow us to enter the jail call that he's talking about so that the court has context to understand why it is so offensive that Mr. Steele is arguing that he gets to suggest to the jury things happen that didn't really happen in the form of his questions to Adrian Bean. So when he's saying, hey, they're telling us to lie, and he's saying, that's, what do you mean? They're saying put Thug in there. Well, what did you mean when you said they gave us a story to tell? Mr. Steele knows what they meant because he says it in the jail call. It's clear. So we can play that for the court. I can point to all of the times that Mr. Steele impermissibly asked questions that assume facts that are not in evidence. He's saying, do you remember stating that the driver was not you? There's nowhere in here that he says that the driver wasn't him. Literally. We just heard it. There's nowhere in here that says that. Now, if he asks this witness, you were the driver, weren't you? And at first you said you weren't the driver, weren't you? And then he says, well, didn't you say to X on this date at this time that you weren't the driver? Because guess what? He can then put forth X and show where he's lying. Right now, he's putting questions on the witness about things that don't exist. So there's no way anybody can test the witness's knowledge on it because they don't exist. That's all that I'm saying, Judge. And that's what I'm asking that the court preclude the defendant from doing from here on out. And I will go through and present to the court. I will literally highlight all of the times that Mr. Steele asked those kind of questions. Do you remember? Why did you tell them this? There's nothing in the record where he told them anything. There's no evidence that has been presented. And Mr. Steele knew what he was doing. He intentionally didn't do it the right way and simply say, you said X, Y, Z. Or this happened, didn't it? I don't remember. But didn't you say X, Y, Z on this date? Instead, he just jumps right to, why'd you lie to the police? Those things are not proper. There's a way to do things, and he has not done them the proper way because he wants to put in the jury's mind facts that don't exist. And that is not the way a trial is done. That's not the way you get at the truth, by lying to the jury through your questions to a witness. And that's what he's done.
Okay. All right. Anything further, Mr. Steele?
I have absolutely nothing to say unless the court wants me to say something. It's just a continuation of the rants of gay love.
And Your Honor,
I didn't ask anybody to laugh in the gallery, okay? This is a courtroom, not some entertainment forum for you.
Did you hear what they said? And y'all, that was not me laughing because somebody tried to act like it was me. Nope, that was not me laughing. That was not me laughing at all. Let me rewind it a little bit. Hold on.
why did you tell them this? There's nothing in the record where he told them anything. There's no evidence that has been presented. And Mr. Steele knew what he was doing. He intentionally didn't do it the right way and simply say, you said X, Y, Z. Or this happened, didn't it? I don't remember. But didn't you say X, Y, Z on this date? Instead, he just jumps right to, why'd you lie to the police? Those things are not proper. There's a way to do things, and he has not done them the proper way because he wants to put in the jury's mind facts that don't exist. And that is not the way a trial is done. That's not the way you get at the truth, by lying to the jury through your questions to a witness. And that's what he's done.
Okay. All right. Anything further, Mr. Steele?
I have absolutely nothing to say unless the court wants me to say something. It's just a continuation of the rants of gay love.
The rants of
And Your
love.
Honor, if
I didn't ask anybody to laugh in the gallery, okay? This is a courtroom, not some entertainment forum for you. Yes.
the insults again, if they're gonna be called rants, I think we should recognize what we're doing. When we stand up and go on and on with hysterics, as Mr. Steele has done, I'd ask that he, be precluded from slinging insults as well.
All right, well, both of you took professional responsibility when you were in law school, and that's not the way that we treat each other as professional colleagues. So I'll just leave you with that. All right. No, I'm gonna let I think I've been asked to take a comfort break, so I'm gonna let everybody take comfort, and then I'll.
Okay, I don't think the judge even really ruled on it at the end. Right here, hold on. Here we go. We're coming back to it. The rant of love.
Before they get into the whole, when he starts saying, yeah, we were in the hospital, we were the victims, he's actually talking about that with his wife, the fact that Walter Murphy and Frederick Protro came down to, I guess, they gave a story to the police
Okay, but-
about them being.
All right, but he's entitled to ask about that. That would go to truth and veracity of his statement.
Right, what I'm saying is.
I think what you're, and correct me if I'm wrong, you're saying that certainly there's a way to ask that question, but I'll have to wait till it's propounded, okay? Okay, all right. Okay, folks, Mr. Beam will be with us tomorrow?
All right, y'all. So
You're
this
certain of that?
Mr. Bean is going to be here tomorrow. I am going to get my butt in the bed so you guys all can be prepared for tomorrow. You guys have a wonderful night. I hope you guys get some rest. And I will be in the courtroom tomorrow morning. Have a great night, y'all. Good night. Thank you for being here. Night, night.